It's phase one.
President Trump signed the executive order 3 months ago, imposing a $100,000 fee on all new H-1B work visa applications. Today, 19 states filed suit to block it, including California.
H-1B visas allow U.S. employers, including our schools, hospitals, universities, research institutions, to hire highly skilled workers like physicians, like nurses, like teachers, and researchers.
State Attorney General Rob Bonta says the executive order is illegal because only Congress has the authority to raise revenue. The old H-1B fee was about $7,500.
California, like every other state in this country, needs more teachers, more nurses, more doctors. There is a shortage.
The H-1B visa program allows employers, including hospitals and schools, to hire foreign workers in order to fill labor shortages.
We have had a continual desire to bring on about 100 nurses for the last 3 years.
Jamie White is a chief nursing officer in Maryland, one of the 19 states that filed suit. She says the $100,000 fee has halted the visa program altogether at her hospital.
We will not afford that. We cannot afford that for even one individual.
The White House says the fee will force employers to hire workers from this country.
So there's an incentive to hire American.
Issuing a statement saying, President Trump promised to put American workers first, and this common sense action does just that by discouraging companies from spamming the system and driving down American wages.
The bottom line is no presidential administration can rewrite immigration law. No president can destabilize our schools, our hospitals, and universities on a whim.
Here in San Diego, the need for nurses is critical. One recent report estimated that over the next 3 years, the region will need 1,500 additional nurses. In Kearney Mesa, David Gottfredson, CBS 8.
There's a story that's not getting nearly enough attention right now. While the media focuses on every outrageous Trump policy announcement, every inflammatory statement, every culture war spectacle designed to dominate the news cycle, something quieter but far more significant is happening. Democratic state attorneys general are waging coordinated legal warfare against the Trump administration's immigration enforcement regime, and they're winning. Not every case, not every time, but enough to matter, enough to slow implementation, enough to force transparency, enough to preserve sanctuary policies and protect hundreds of thousands of immigrants from policies that are flagrantly illegal. This isn't symbolic resistance. This isn't performative opposition. This is the use of institutional state power to create actual barriers. Legal infrastructure that constrains executive overreach, preserves constitutional limits, and buys time for people to organize, access legal help, and prepare. In Trump's first term, Democratic state attorneys general filed 138 lawsuits. In just the first 11 months of his second term, they're already on pace to exceed that. California alone has filed 49 lawsuits since January. And here's what's remarkable. It's working. Federal judges have blocked the birthright citizenship executive order. Courts have preserved congressional oversight of immigration detention facilities. The Supreme Court, for the first time in 11 months, denied a Trump administration emergency request, allowing immigration judges to challenge a gag rule on their speech. States are maintaining sanctuary policies despite federal threats. They're forcing discovery. They're creating precedent. And they're demonstrating that organized, coordinated state resistance can actually constrain a president who believes he's above the law. Let's decode exactly what's happening, why it matters, and what it reveals about the power of federalism when wielded deliberately against authoritarianism. Let me walk you through the timeline, because it's not just one lawsuit. It's a systematic campaign. January 21st, 2025, the day after Trump's inauguration, 22 states, plus DC and San Francisco, sued over Trump's executive order attempting to end birthright citizenship. The order targeted children born to undocumented parents or temporary visa holders, at least 150,000 children per year. Federal judges in Massachusetts and Seattle issued temporary restraining orders within 24 hours. May 13th, 20 states sued over federal funding coercion. Trump threatened to withhold billions in FEMA disaster relief and Department of Transportation infrastructure funds unless states enforced ICE detainer requests. California Attorney General Rob Bonta called it a blatantly illegal attempt to bully states. July 1st, 20 states sued over the Department of Health and Human Services sharing Medicaid data with DHS and ICE. Without consent, without notice, the federal government took healthcare records from California, Illinois, Washington, and DC and turned them over to immigration enforcement. The lawsuit demands destruction of all transferred data. August 18th, 21 states, plus DC, sued over crime victim grant conditions. The Justice Department withheld over $1 billion in Office for Victims of Crime grants, funding that pays for domestic violence hotlines, rape crisis centers, shelters, counseling services, hate crime victim support. The administration tried to condition those grants on states helping ICE deport people. September, DHS sent ultimatums to California, New York, and Illinois demanding compliance with ICE detainer requests within 48 hours. The states refused. DHS threatened lawsuits and funding cuts. But here's the thing. Federal regulations explicitly say detainer requests are requests, not mandates. And courts have repeatedly ruled that holding people beyond their release date without a judicial warrant violates the Fourth Amendment. November 26th, 21 states plus DC sued over SNAP, food aid, cuts for legal immigrants. The USDA reinterpreted existing law to declare refugees, asylees, and humanitarian parolees permanently ineligible for food assistance. Even legal immigrants with green cards who meet all standard SNAP requirements. Tens of thousands of people cut off from food. December 13th, 20 states sued over Trump's $100,000 H-1B visa fee. That's up from $2,000 to $5,000. The fee targets skilled workers, teachers, nurses, doctors, researchers. There are 30,000 educators on H-1B visas right now, and 74% of U.S. school districts report teacher shortages. Hospitals in low-income neighborhoods rely on H-1B physicians. Universities rely on H-1B researchers. The new fee makes hiring them economically impossible. December 17th, Trump expanded the travel ban from 19 countries to 39. 17 countries face full immigrant and non-immigrant visa bans. 15 face partial restrictions. Palestinian Authority travel documents, full restriction. Effective January 1st. December 18th, USCIS froze all immigration petitions, citizenship applications, green card applications for nationals of the 39 banned countries. That includes people already in the United States seeking status changes. That's 11 months. That's not resistance. That's a coordinated legal siege. States are maintaining sanctuary policies despite federal threats. They're forcing discovery. They're creating precedent. And they're demonstrating that organized, coordinated state resistance can actually constrain a president who believes he's above the law. Let's decode exactly what's happening, why it matters, and what it reveals about the power of federalism when wielded deliberately against authoritarianism. Now let's talk about what these lawsuits have actually accomplished. On December 17th, a federal court ruled that House Democrats' lawsuit challenging immigration enforcement abuses can proceed. That preserves congressional oversight, the ability to conduct investigations, demand documents, compel testimony. The Trump administration tried to block discovery. The court said no. On December 20th, the Supreme Court denied the Trump administration's emergency request to halt an immigration judge's lawsuit. The National Association of Immigration Judges is challenging a gag rule that prevents them from speaking publicly about immigration policy. Trump wanted the case stopped immediately. The Supreme Court refused. That's significant. According to The Hill, this is Trump's first loss on the Supreme Court's emergency docket in 11 months. His administration has filed 32 emergency applications. This is the first one they lost. And the birthright citizenship injunctions are still in place. Federal judges blocked that executive order, and it hasn't been implemented. These aren't Pyrrhic victories. These are actual constraints on executive power. Every lawsuit creates discovery obligations. The administration has to produce documents. They have to answer interrogatories. They have to defend their policies under oath, in front of judges, with evidence. Every injunction creates delay, and in immigration enforcement, time matters. Time for people to access legal help, time to organize, time to prepare, time for families to make plans, for communities to mobilize, for advocacy organizations to coordinate. Every precedent constrains future administrations. When a court rules that birthright citizenship can't be eliminated by executive order, that doesn't just apply to Trump. It limits what any future president can do. This is how institutional resistance works. Not through drama, through process. Through litigation that forces transparency and creates legal infrastructure. That's 11 months. That's not resistance. That's a coordinated legal siege. States are maintaining sanctuary policies despite federal threats. They're forcing discovery. They're creating precedent. And they're demonstrating that organized, coordinated state resistance can actually constrain a president who believes he's above the law. Let's decode exactly what's happening, why it matters, and what it reveals about the power of federalism when wielded deliberately against authoritarianism. Let's zoom out and look at the pattern. Trump isn't just enforcing immigration law more strictly. He's attempting to rewrite it through executive fiat, agency proclamation, and funding coercion, entirely bypassing Congress, the courts, and administrative procedure. He tried to eliminate birthright citizenship. That's in the 14th Amendment. It says explicitly, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. You can't change that with an executive order. But he tried. He's conditioning federal grants, disaster relief, infrastructure funding, crime victim services on states enforcing immigration detainers. That's Congress's money. Congressional appropriations. The president doesn't get to add new conditions after Congress has already decided how the money will be spent. But he's doing it anyway. He imposed a $100,000 H-1B fee with zero notice and comment rulemaking. The Administrative Procedure Act requires agencies to publish proposed rules, accept public comment, and justify their decisions. That didn't happen. But the fee went into effect anyway. He's sharing Medicaid data with ICE, turning healthcare into a surveillance tool. People who are legally eligible for Medicaid, citizens, green card holders, refugees, are now afraid to seek medical care because their information might be handed to immigration enforcement. He's denying food assistance to legal immigrants who have green cards and meet all eligibility requirements. The USDA just reinterpreted the statute to exclude entire categories of people that Congress explicitly made eligible. Every one of these actions violates either the Constitution, federal statute, or administrative law. And every one has been challenged in court by Democratic state attorneys general. This is how institutional resistance works, not through drama, through process, through litigation that forces transparency and creates legal infrastructure. That's 11 months. That's not resistance. That's a coordinated legal siege. States are maintaining sanctuary policies despite federal threats. They're forcing discovery. They're creating precedent. And they're demonstrating that organized, coordinated state resistance can actually constrain a president who believes he's above the law. Let's decode exactly what's happening, why it matters, and what it reveals about the power of federalism when wielded deliberately against authoritarianism. You might wonder, why are state attorneys general leading this resistance? Why not Congress? Why not civil rights organizations alone? The answer is capacity, resources, and standing. State attorneys general have institutional authority. They have legal teams. They have budgets. When they sue as a coalition, 20 states, 22 states, they can pool expertise, share litigation costs, and present a unified front. They also have standing. That's a legal term that means you have the right to bring a lawsuit. States can argue that federal policies harm their residents, their institutions, their economies. They can show injury in ways that individual plaintiffs sometimes can't. A state can say, the H-1B fee harms our universities, our hospitals, our school districts. We can't hire the teachers and doctors and researchers we need. That's concrete injury. That gives them standing. A state can say, federal funding coercion violates our sovereignty under the 10th Amendment. You're trying to commandeer our law enforcement resources. That's a constitutional claim with teeth. And when 20 or 22 states sue together, they're not just one jurisdiction that the administration can dismiss as an outlier. They represent a significant portion of the country's population and economy. California alone has filed 49 lawsuits against the Trump administration since January. That's not symbolic. That's sustained, systematic use of state legal power to constrain federal overreach. This is how institutional resistance works, not through drama, through process, through litigation that forces transparency and creates legal infrastructure. That's 11 months. That's not resistance. That's a coordinated legal siege. States are maintaining sanctuary policies despite federal threats. They're forcing discovery. They're creating precedent. And they're demonstrating that organized, coordinated state resistance can actually constrain a president who believes he's above the law. Let's decode exactly what's happening, why it matters, and what it reveals about the power of federalism when wielded deliberately against authoritarianism. Let's talk about how the Trump administration frames these lawsuits. Because the language matters. They call Democratic-led states sanctuary cities that harbor criminals. They claim states are refusing to cooperate with ICE, allowing criminal aliens to go free. Notice the language. Criminal aliens. Not immigrants charged with crimes. Not people accused of offenses. The phrase itself conflates immigration status with criminality. It's dehumanizing by design. And the framing erases a critical distinction. States aren't preventing ICE from enforcing federal law. They're declining to do ICE's job for free using state resources. ICE has the authority to enforce immigration law. They have agents. They have budgets. What they don't have is the power to commandeer state and local police to do their work for them. That's federalism. That's the 10th Amendment. States get to decide how to allocate their own law enforcement resources. And when states choose not to hold people in jail beyond their release date just because ICE asked them to, that's not obstruction. That's sovereignty. The administration also frames judicial review as activist judges overruling the president. They invoke plenary power over immigration, the idea that the executive has broad, unreviewable authority. But that's a distortion. Plenary power applies to border control and decisions about who gets admitted to the country. It doesn't mean the president can violate the Constitution, ignore statutes, or bypass administrative procedure in the interior. When Trump tries to eliminate birthright citizenship, that's not plenary power. That's attempting to rewrite the 14th Amendment by executive order. When he conditions federal grants on immigration enforcement, that's not plenary power. That's usurping Congress's appropriations authority. The administration is trying to turn executive authority over immigration into a blank check. And the courts, pushed by state lawsuits, are saying no. Let's decode the language the administration is using to defend these policies. When ICE says congressional visits require 7 days' notice for security reasons, what they're really saying is, we need time to control the narrative. When they say attorney access restrictions are about operational capacity, what they're really saying is, we don't want lawyers interfering with our process. When they say rapid transfers are logistically necessary, what they're really saying is, we're prioritizing speed over due process. This is classic bureaucratic euphemism. You take something that serves your political goals, limiting oversight, blocking lawyers, accelerating deportations, and you describe it in neutral, managerial language. It's not about hiding abuses. It's about security procedures. It's not about denying representation. It's about operational efficiency. It's not about avoiding accountability. It's about resource management. But courts aren't buying it. Judge Cobb didn't accept the argument that congressional oversight is a logistical burden. She recognized it as a constitutional function that can't be conditioned on advance notice. And in Oregon, attorneys are presenting evidence that these so-called operational necessities are actually systematic barriers to representation. The legal system is forcing the administration to stop using euphemisms and defend the substance of what they're doing. And that's uncomfortable for them, because the substance is, we don't want oversight, and we don't want lawyers slowing down deportations. You might wonder, why are state attorneys general the ones bringing these cases? Why not Congress? Why not the ACLU alone? The answer is capacity and coordination. State attorneys general have resources, legal teams, and institutional authority. When they sue as a coalition, like the 22 states that challenged the administration's funding coercion tactics, they can pool expertise, share litigation costs, and present a unified front. They also have standing. States can argue that federal policies harm their residents, their institutions, and their economies. That gives them a path into federal court that individual plaintiffs might not have. And politically, this is part of a broader resistance strategy. Democratic-led states are using every institutional tool they have, legislation, executive action, and litigation, to push back against Trump administration policies they see as unlawful or harmful. Critics call this obstruction, but that's not what's happening here. These lawsuits aren't challenging the administration's authority to enforce immigration law. They're challenging specific practices. restricting congressional oversight, blocking attorney access, coercing states with funding threats that appear to violate federal statutes, due process, or constitutional limits on executive power. That's not obstruction. That's accountability. And it's working. Multiple courts have issued temporary blocks or moved cases forward to evidentiary hearings. The administration has been forced to defend policies it probably hoped would just be implemented quietly. Here's what you need to understand about why this matters beyond immigration. Detention systems. Any detention systems require oversight. Not because everyone detained is innocent. Not because enforcement is inherently wrong, but because governments that operate detention facilities without scrutiny have a documented history of abuse. This isn't ideological. It's empirical. When Congress can't conduct unannounced inspections, conditions worsen. When attorneys can't reach clients, legal rights become theoretical. When families can't locate detainees, people disappear into the system. The Trump administration is creating those conditions deliberately. They're not trying to make enforcement more effective. They're trying to make it less visible. And that should concern everyone, regardless of where you stand on immigration policy, because the tools being used here can be applied elsewhere. If the executive branch can block congressional oversight of immigration detention, what stops them from blocking oversight of prisons, of military facilities, of federal law enforcement operations? If they can restrict attorney access in immigration cases, what stops them from doing it in other civil or administrative proceedings? These are precedents. Once established, they don't stay confined to their original context. The cases we're talking about are ongoing. The D.C. ruling blocking the congressional notice requirement is temporary. The administration will almost certainly appeal. They might ask for a stay. They might argue that the judge overstepped. In Oregon, the evidentiary hearing is just one stage. The court will issue a ruling. Then there will be appeals, possibly all the way to the Supreme Court. And the broader coalition cases on funding coercion, on SNAP restrictions, on visa fees are moving through their own procedural tracks. This is going to take time, and there's no guarantee the courts will side with the states on every issue. But here's what the litigation has already accomplished. It's forced the Trump administration to defend its policies in public, under legal scrutiny, with a record that can be reviewed and challenged. That's not nothing. Without these lawsuits, ICE would have implemented the 7-day notice requirement nationwide. Members of Congress would be scheduling visits weeks in advance, seeing curated versions of detention facilities. Attorneys would be blocked from field offices without any legal recourse. Detainees would be transferred across the country with no one tracking where they went. The lawsuits didn't stop all of that, but they slowed it down. They created opportunities for judicial review. They forced transparency. And that's the power of litigation as resistance. It's not a magic bullet. It's a tool. A way to force governments to justify their actions, to defend their policies, to operate within legal constraints. Let's be very clear about what's at stake here. This isn't about whether you support strict immigration enforcement or a path to citizenship. This isn't about border security or sanctuary cities. This is about whether the government can operate detention systems beyond the reach of oversight, whether attorneys can access clients, whether members of Congress can inspect facilities, whether due process is a real thing or just a phrase we say. The Trump administration is betting that most people won't notice, that immigration detention isn't sympathetic enough to generate public pressure, that the courts will defer to executive authority. But so far, they're losing that bet. Judges are blocking policies. States are coordinating legal challenges. Attorneys are fighting for access. Members of Congress are demanding the ability to do their jobs. And the administration is being forced to defend itself, not in press conferences where they can spin the narrative, but in courtrooms where facts and law matter. That's accountability. Imperfect, slow, grinding, but real. And it's happening because Democratic-led states decided that even if they couldn't stop the administration's immigration agenda, they could force it to operate within legal boundaries. That's the fight. Not over policy preferences, over process, over transparency, over the basic mechanisms that keep power in check. The administration is trying to lock the doors. The courts are forcing them back open. And what happens next will tell us a lot about whether our system of checks and balances still works, or whether those checks only matter when it's politically convenient. This is the test. We're watching it happen in real time. And what we do or don't do in response will shape what's possible in the years to come.
Thanks for spending a few minutes digging into this with me. If you want more grounded, progressive commentary without the outrage bait, subscribe and stick around. Every time you watch, share, and engage, it helps build a community that believes democracy is worth understanding and defending. I'll see you in the next video.